Hello, everyone. In this lecture podcast, we talk about the sources of international law as part of the podcast and learning resources for our course in LAWS12070 on public, international, and human rights law. This is a lecture podcast that is prepared by Dr. Manjo, Oyson. Let's begin by asking two basic questions. So we would like to know more about international law. And we begin by asking the question, where exactly do we find the substantive rules or laws of international law? What exactly are they? Now, if we examine domestic legal systems, the question about what the sources of laws are and what the laws might be of a domestic legal system is not really problematic, because what you then do is examine the constitution of a state or of a domestic legal system. You can examine its statutes and the laws passed by its parliament. You can examine its judicial decisions, as well as whatever regulations might have been passed or created by the executive. So in that case, by going to certain sources of law, then you become aware about both the substantive and procedural rules or laws of a domestic legal system. The problem, however, as we know from week one, the problem in relation to international law is that there is no world or international parliament. In other words, there is no legislative body in the world or the international legal system that passes laws that would be binding on states. It does not exist. So the United Nations is not a world parliament that passes laws that become binding on the member states of the UN. It is not. And neither is there a world court that makes laws in the sense that any decision by a world court also becomes automatically a binding source of law on states. That is, again, not the case, because unlike in most domestic legal systems where judicial decisions become part of the legal system, mainly because of the principle of stare decisis, which means that courts are meant to follow the judicial decisions of past courts on the premise that there should be some sense of judicial precedence that should be followed in order to ensure that there is some uniformity in the decisions of the courts. The world court, there is no world court, and even as far as the International Court of Justice is concerned, the principle of stare decisis does not really apply. And unlike courts of domestic legal systems, which have compulsory jurisdiction over subjects of a state, even the International Court of Justice does not have compulsory jurisdiction over states, as we examine in detail in the succeeding weeks. Now, so what we're going to do, given the fact that it poses a big question as to what the sources of international law are, that is the subject of this particular lecture podcast. And so in terms of objectives, after studying this topic, you should be able to discuss and explain the sources of international law, as well as the legal basis for the binding character of international law. Now, going back to domestic legal systems, it is assumed, and it is simply assumed, that on the basis of state sovereignty, any law that is passed by a domestic parliament, so such as in the case of Australia, the Commonwealth Parliament, its laws are automatically binding upon all subjects of Australia and upon all who live within Australia. And for that reason, we know that domestic laws or laws passed by the Australian Commonwealth Parliament are compulsory and obligatory. And we know that the compulsory and obligatory nature of domestic laws passed by the Australian Commonwealth Parliament do not rest on the consent of the subjects of Australia. They simply are assumed to be compulsory and binding upon all who live or reside within Australia. In fact, in order to emphasize the binding and compulsory nature of domestic laws, there is a Latin maxim which says, ignorantia legis non excusat, which in English means ignorance of the law excuses no one, which emphasizes the fact that we might not be aware of a domestic legal system's laws, and yet that will not excuse us from having to comply with it. Now, in contrast, because as stated, there is no world or international parliament that makes laws that are binding on states. International law, therefore, rests essentially on the express or implied consent of states. Now, we're going to examine this again in a short while, but as a general proposition, it is conventionally understood that the binding character of international law is a result of the express or implied consent of states. And we can see this in the fact that, for example, as far as treaties are concerned, when states enter into treaties and enter into binding legal obligations, therefore, their entry into treaties signifies their intention to be bound by their treaty obligations. So it is based on their consent. No one forces a state to enter into a treaty. As far as customary international law is concerned as well, as we examine later on, customary international law is a result of consistent state practice that recognizes that there is a binding element to the practice that is being conducted or performed by states. Again, it rests on the consent of states. They are following certain customary international law because they agree to be bound by it, at least initially. So what that assumes is that as far as international law is concerned, states continue to be sovereign within their own spheres. There is no international body which can dictate upon states on what they should be doing and whether or not they should enter into certain legal obligations under international law. Now, this conventional view was in fact adopted in the Lotus case, which was the case of France versus Turkey, where the Permanent Court of International Justice, which was the prior World Court prior to the International Court of Justice. And in that case, the Permanent Court of International Justice acknowledged that a purported rule cannot bind a state that has not agreed to be bound by it. And in particular, if you examine the Lotus case, what had happened there in that specific case was that Turkey had tried to assert criminal jurisdiction over a French citizen who had been the officer of the watch on board the Lotus ship at the time that it collided with a Turkish vessel, which resulted in casualties and damage to the Turkish vessel. Now, France objected to the assertion of criminal jurisdiction by Turkey. It asserted that because the incident had occurred in the high seas, then it had to be the flag state. So in relation to the French vessel, therefore, it had to be the case that the French officer could only be tried by France and could only be under the jurisdiction of France. But Permanent Court of International Justice, however, ruled that Turkey had, in fact, a concurrent jurisdiction to prosecute the French officer by observing that under international law, restrictions upon a state, so restrictions such as restrictions on when it can exercise criminal jurisdiction, that those kinds of restrictions cannot be presumed, and that international law continues to recognize that states have a wide measure of discretion, which is only limited in certain cases by prohibitive rules. And some of those rules may relate, for example, to jus cogent norms or norms of international conduct that are considered to be so important that they are considered to be binding upon states. And in that case, as far as jus cogent norms are concerned, such as norms against slavery or piracy or genocide, those rules simply become binding on states, and states, in fact, are not permitted to opt out of the binding nature of those norms. And the court also stated in the Lotus case that the rules of law binding upon states therefore emanate from their own free will, as expressed in conventions or by usages generally accepted as expressing principles of law and established in order to regulate the relations between those coexisting independent communities or with a view to the achievement of common aims. So to emphasize there, the court underlined and highlighted that the rules of international law, their binding character, emanate from the free will of states. However, if we accept as unqualified the idea that international law rests solely based on consent, it leads to certain problems. The first being, as I mentioned earlier, is that there are certain jus cogent norms that are binding upon states, and the binding nature of jus cogent norms does not rest on state consent. In fact, states are not even given the right nor the power not to disregard or to disobey jus cogent norms. Jus cogent norms, by their very nature, are binding upon states regardless of their consent. And it is relatedly, this is the reason why several jurists and academics argue that the traditional view of international law as resting solely on state consent is not feasible in the context of contemporary world problems, and therefore is largely fictitious. And what exemplifies this would be the near universal international concern over certain issues and problems such as transnational environmental harm, terrorism, human rights violations, and climate change, which highlight the need for a softening of the requirement of state consent for a binding rule of international law. And so what a lot of jurists and academics are saying is that given the importance of certain issues such as transnational environmental harm and terrorism, the binding character of rules of international law that may prohibit the use of terrorism, or which may seek to impose upon states an obligation to avoid transnational environmental harm or harm upon other territories or upon the territories of other states, that the source of obligation on relation to these matters is not based on the consent of states, but it is based on the idea that given the importance of these issues, there will arise certain legal obligations on the part of states regardless of their consent. Now, this position, which represents a weakening of the notion of international law being based on state consent, was reflected in the case of Congo versus Belgium, in the separate opinion of Judges Higgins, Kujemans, and Bergenthal. And in that particular case, these judges said that certain criminal acts, such as war crimes, hijacking, hostage-taking, torture, and crimes against humanity, may in fact attract universal criminal jurisdiction and the application of international law, notwithstanding the lack of consent by a state to such jurisdiction. So a good example might be the case of the Philippines, where its current president, Rodrigo Duterte, after taking office in June 2016, has implemented a state policy of killing drug suspects. And when we speak of drug suspects, these not only are those who are involved in the selling and trading of illegal drugs, but drug suspects are also those who are users of illegal drugs. So those who use illegal drugs potentially can be subject to state-sponsored killings through the use of death squads. And as a result, within 5 months from taking office as president of the Philippines, there have now been more than 5,000 individuals who have been killed using, on the basis of the state-sponsored policy of the war against drugs. And the question that arises is, would it be permissible, or is it possible for Duterte, for example, to evade prosecution from these acts, which might be called crimes against humanity, or which might in fact be genocide, because it's actually targeting a specific sector of society. And in fact, most of those who are killed belong to the poorer economic class. And the question arises of whether or not he is bound by norms of international law against crimes relating to crimes against humanity or genocide, even if he does not consent. And the answer is yes. Duterte will still be held liable for crimes against humanity and genocide, even if he refuses to recognize the application of certain norms of international law in relation to him. And we ponder this question as well in relation to the acts of the current president of Syria, Bashar al-Assad, who has also been accused of committing crimes against humanity against civilians, because thousands of civilians have died in Syria as a result of the fight between the Syrian government headed by Bashar al-Assad and certain rebel groups, many of which had initially been supported by Western states. Now, the other point we need to consider is that certainly there are norms that are based on consensus. So certain norms or certain conduct that states perform, they do so on the basis of their consent, and there's consensus around it. But in fact, there are also certain universal norms which ought to be obeyed by states regardless of their consent. And as stated earlier, this could relate to hijacking, terrorism, as well as crimes against humanity. And therefore, if we look at international law as being founded solely on state consent, then we have problems in relation to states which are deemed to be maverick or outlaw states. And these might include North Korea or even Syria. And in that case, if they refuse to observe norms of international law, would it therefore mean that they exist outside of international law? And how about states that refuse or deny the jurisdiction of the International Criminal Court of Justice? If international law rests solely on consent, would it mean that certain states may then, and especially its government officials, they then may no longer be subject to the jurisdiction of the International Criminal Court of Justice? And how then do we deal with superpower states, which might include the United States, Russia, and China, which typically act unilaterally in opposition to the position of a majority of other states? Does it mean, therefore, that given the their status as superpowers with their strength lying both on their military might as well as economic prowess, doesn't mean, therefore, that these superpower states can freely do whatever they like, regardless of whatever norms of international law might already exist. And the answer, obviously, in relation to all these questions, will have to be a no. Now, so we then examine the question of what then are the sources of international law. And a convenient way of determining the sources of international law would be to examine Article 38, Paragraph 1 of the Statute of the International Court of Justice. And according to Brierly, one of the most influential and well-respected publicists, in his book, In the Law of Nations, he states that Article 38.1 of the International Court of Justice statute is a text of the highest authority, and we may fairly assume that it expresses the duty of any tribunal which is called upon to administer international law. And in fact, we are citing Brierly at this point because, as we later know, the writings of publicists are actually subsidiary sources of international law as well. Now, going back to Article 38, Paragraph 1, therefore, of the ICJ statute, that particular provision commands authority because the ICJ statute requires the ICJ to apply that specific provision in deciding disputes that are submitted to it. And we must remember that the United Nations has for its main judicial organ the ICJ. So typically, most disputes between states are submitted by states to the ICJ for adjudication. Now, what does the ICJ statute, in particular Article 38, Paragraph 1, state? That provision states that the court, whose function is to decide in accordance with international law, such disputes as are submitted to it, shall apply, 1, international conventions, whether general or particular, establishing rules expressly recognized by the contesting states. Secondly, it shall also apply international custom as evidence of general practice accepted as law. Third, it shall apply the general principles of law recognized by civilized nations. And finally, subject to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of the various nations. These shall be subsidiary means for the determination of rules of law. Now, let's examine these 4 sources of law next. Now, international conventions are actually commonly referred to as treaties. And we have a definition of a treaty in Article 2 of the 1969 Vienna Convention of the Law of Treaties. And the Vienna Convention of the Law of Treaties is a multilateral convention or a multilateral treaty of its own, which has as its parties most states. So most states of the world today are actually parties to the 1969 Vienna Convention of the Law of Treaties, and therefore are bound by that specific convention by becoming parties to the treaty. And under the Vienna Convention of the Law of Treaties, a treaty is an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in 2 or more related instruments, and whatever its particular designation. Let me just state initially that in the succeeding week, we will talk more about the law of treaties. So in week 3, we will delve deeper into the law of treaties. Now, going back from the definition of a treaty under Article 2 of the 1969 Vienna Convention on the Law of Treaties, you will notice that a treaty has 4 particular elements or aspects. One is that it has to be an international agreement. Two, it must be concluded between states. So it cannot be between a state and an international organization or between international organizations. So to be a treaty that is covered by the 1969 Vienna Convention on the Law of Treaties, a treaty must be, or international agreement must be concluded between states. It must be in written form, and it must be governed by international law. Now, given the definition of a treaty, these then are examples of what are not treaties. So a mere declaration of intentions between states is not a treaty, because a mere declaration of intentions does not constitute an agreement. As well, if there is an international agreement between say, Australia and Microsoft Corporation, or with a private company, such as for the supply of software or certain items or goods, that agreement is not between states. And for that reason, cannot be, even if it is an international agreement, it cannot be a treaty under the 1969 Vienna Convention on the Law of Treaties. If there is also an oral agreement between two states, such as an oral agreement between China and the United States, because such an agreement is oral and it is not in written form, that will not be a treaty under the Vienna Convention on the Law of Treaties. And if there is an agreement, let's say between the United States and Honduras, for the lease of a tract of land in Honduras, which is to be governed by Honduran law, because that particular agreement, as agreed by the parties, is to be governed by a domestic law and not by international law, then that agreement cannot also be a treaty. Now, a second source of international law would, of course, be international custom, which, under Article 38(1), subparagraph B of the ICJ statute, is evidence of general practice accepted as law. So, customary international, therefore, arises from a general and consistent practice of states. So you know that there is potentially a customary international law when there has been a general and consistent practice of states. But more importantly, there is a requirement that not only must there have been a general and consistent practice of states, the states must have been undertaking that practice out of a sense of legal obligation. So according to Brierly, for a customer practice to be considered customary international law, it must be something more than mere habit or usage. It is a usage felt by those who follow it to be an obligatory one. There must be a feeling that if the usage is departed from, there would be some form of sanction, probably, or at any rate, ought to fall on the transgressor. So, for a customer practice to be customary international law, there must be two crucial requirements. One is that there is a general and consistent practice by states, which we will simply call state practice. But at the same time, that practice must have been undertaken because it is accepted as law, or one that is legally obligatory. And so therefore the practice is not merely out of habit or usage. So in other words, in this particular case, there is a subjective element known as opinio juris sivi necessitatis, or what we simply call opinio juris. So there is that subjective sense of legal obligation. So as far as the general and consistent practice by states is concerned, that is an objective element because you can see it. It is a practice. It is a behavior. It is an action. So you know what a practice is. It is objective. But as far as that sense of legal obligation is concerned, so when a state performs a certain act, the question arises, is that state performing that act because it feels bound, legally bound to do so? Now that is a subjective element because it requires an interpretation, an analysis of the meaning and of the character of the act itself. And that also then leads to the problem, the issue of the opinio juris leads oftentimes to a problem because it involves an analysis of what the meaning is or what legal significance should be given to a practice of a state, because the question arises whether or not a state is performing a certain practice as a result of a sense of legal obligation. Now, the other crucial point is, because we know that customary international law must have state practice as well as opinio juris, it tells us that opinio juris by itself without state practice cannot give rise to customary international law. So there is a requirement not only that there is a sense of legal obligation on the part of a state, but there must actually be conduct or behavior or actions, and in other words, practice on the part of states. In the case of Nicaragua versus United States merits, in the case of military and paramilitary activities in and against Nicaragua, or the Nicaragua case, the International Court of Justice stated that for customary international law to be established, the court must satisfy itself that the existence of the rule in the opinio juris of states is confirmed by practice. So in other words, these two elements, opinio juris and state practice, must coexist for there to be a finding that customary international law exists. Now, a third source of international law under the ICJ statute, particularly Article 38(1), subparagraph C, the statute states that general principles of law recognized by civilized nations shall also be applied by the ICJ as a source of international law. Now, what exactly does that mean? What exactly are general principles of law recognized by civilized nations? Now, let's have an example. Now, let us assume that there is a dispute between two states. And the dispute arose because State A, concerned, for example, about a potential naval invasion by another state, has placed naval mines in its own territorial waters. Now, let's assume that some of these mines have drifted into international waters and caused damage to a ship of State B. Now, let's assume that State B therefore files an action against State A before the International Court of Justice. And let's assume that there is no treaty that was entered into by the parties that would govern this particular problem. And let's assume that there is no customary international law that governs the dispute relating to damage to a ship as a result of the laying of naval mines by a state. And so the question is, if there is no treaty and there is no customary international law relating to the dispute, the question is, what law then can the ICJ apply in deciding this dispute? So in that case, in that particular dispute, the ICJ will apply general principles of law recognized by civilized nations. And we will notice that because the ICJ is given the duty to apply general principles of law recognized by civilized nations, the court then is in a position to decide on a dispute, because it can then look for general principles of law that have been recognized by civilized nations. Because otherwise, had the court been limited to looking for treaties or customary international law to make an adjudication on the dispute, then there would have been no source of law that it could examine or have recourse to. But because the court can decide a dispute on the basis of general principles of law recognized by civilized nations, the court then is in a position to decide a controversy or a dispute. Now the question arises, what then do the general principles of law relate to? Are they general principles of municipal law, or are they general principles of international law? Now, broadly speaking, these general principles relate to principles of municipal law, or the laws of states, that are generally recognized by civilized nations. In other words, most civilized nations recognized the importance or the binding character of certain general principles. And examples of these would be good faith in the creation and performance of legal obligations, natural justice, equity, estoppel, obligation to make reparation, res judicata, and proportionality. And we will notice that these principles are actually principles which are familiar to us in Australia. And these principles happen to be familiar in most other municipal legal systems. And these principles, therefore, are applied in many cases by most states and by the respective courts. Now, so what this tells us is that in a sense, the application of general principles of law can be compared to what judges of common law systems do. So as we know, in common law systems, despite the absence of a statute that can govern a particular dispute or a subject matter, or a controversy between parties, or even in the absence of a judicial precedent, judges of common law systems will not shirk from its responsibility of deciding a dispute. So judges of common law systems will not say that they cannot decide on a case because there is no statute or a judicial precedent that is applicable. What judges in common law systems are required to do is to decide a case still, and if necessary, make what is known as judge-made law. So that is what typically happens in common law legal systems. And in relation to the International Court of Justice, the International Court of Justice and its judges will continue to decide a case, notwithstanding the absence of a treaty or a customary international law that relates to a dispute, and it does so by looking for general principles of law recognized by civilized nations. Now we go back to that basic question we have, whether or not general principles of law recognized by civilized nations relate to municipal law or of international law. And in fact, the author of our prescribed text, Abbas, is making the assertion that as far as general principles of law, there is a subset of general principles of international law as opposed to general principles of municipal law. Now, I would argue that that distinction is in fact unnecessary, since if a general principle of law that is common in domestic legal systems, in other words, if these are general principles of municipal law, such as equity or estoppel, if these are commonly or generally recognized by civilized nations, then arguably those general principles would then obtain the status of a general principle of international law. So in other words, what initially would have been general principles solely of municipal law, when applied and observed by the International Court of Justice, they actually attain the status of general principles of international law. So, examined in this light, a general principle of international law is a general principle of law that emanates or derives from municipal law systems that, because of the general recognition by civilized nations, can be considered as a general principle of international law. And so finally, we examine the last source of international law, which, according to Article 38, paragraph 1, subparagraph D of the ICJ statute, relates to judicial decisions and the teachings of the most highly qualified publicists of the various nations, which are to be subsidiary sources of international law. So because these are subsidiary sources, they are not primary sources of international law, and as subsidiary sources, they actually supplement what exists in international law as its own sources. So if you were to speak of a hierarchy of sources of international law, the primary sources of international law would be treaties, customary international law, and general principles of law recognized by civilized nations, and then judicial decisions, whether of municipal systems or of the ICJ or of an international court, as well as the teachings of the most highly qualified publicists of the various nations. These will become subsidiary sources of international law. Now, as I said, these are considered subsidiary because they are not sources of law on their own, but are only used to strengthen the other sources of international law, such as treaties, customary international law, and general principles of international law. Now, in relation to judicial decisions, they may be those of domestic as well as international courts. And in relation to qualified publicists, a lot of these are well-known and highly qualified publicists, such as Brierley, which I have been citing in this lecture podcast quite frequently. You also have Oppenheim, you have Brownlee, Jennings, Grotius, and others. So after going through this lecture podcast and after studying this topic, you should be able to discuss and explain the legal basis for the binding character of international law and the sources of international law.